So great. Good morning, everyone, and welcome to our session today, Application of Force Majeure Clauses During a Pandemic. My name is Carrie Lee Auger. I'm the Skills Development Manager here at Women's Enterprise Center. And in my role, I look after all our training, education, and resources that we create to support women entrepreneurs as they build and grow their businesses. At Women's Enterprise Center, for those of you who may not be familiar, or this is one of your first sessions, we help women business owners to realize their business potential through business loans of up to $150,000. We have professional advice and resources through our client service and business advisory teams. We have skills training such as this forum here today. We have mentoring programs in a one-to-one peer mentoring format or taking the stage groups. And we offer supportive communities through groups and activities such as this. So thank you for joining us. And we do all of this through our offices located here in Kelowna, Victoria, and Vancouver. And while most of us are working from home now, those are the three main centers where you will find our team. Plus, we have regional ambassadors and entrepreneurs in residence located throughout the province to support you as well. One of the other resources that we have for you during this time is our COVID-19 resource page. And I'm just going to pull that up. Actually, I have it open for you here just to kind of show you how valuable it can be. So we have lots of the updates of upcoming training and webinars such as this that you can participate in. We keep track of the government updates on a regular basis. So as they're rolling out, continuing, amending some of the programs, you can find updates on that as well. And lots of recordings of our previous sessions that were done during this time to support you. Access to lots of valuable resources as well. And we're going to continue to have that page available to you for the foreseeable future because there are lots of valuable resources there that you can take part in. And as well, I want to just jump back for our session today. Sorry, 1 second. There we go. To participate with us today, we're going to use the Q&A and the chat features as well. So you should see those on the bottom of your screen. And we will be taking a few breaks throughout, so Deirdre will be able to answer some of the specific questions that you might have. It is great if you want to just, as those questions come up, jot them down in that chat or the Q&A. If they end up being answered during the session, that's great. But my colleague Danielle, who is here supporting me today as well, we're going to manage that and go through and make sure that we try and get as many of your questions answered as possible. So the chat is a great way for you to throw those in there to get us started as we go through the session, and we can keep track for you. So again today, very pleased to have with us Deirdre Huestis from Borden Ladner Gervais BLG, the Driven by Women series. Today we're going to be talking about force majeure contract law. So what are some of those unforeseeable circumstances that might prevent you or someone from fulfilling a contract, and how does it apply to your business right now during COVID-19? So the pandemic could continue to bring many assertions of this force majeure clause in response to quarantines, business closures, travel restrictions. So in today's session, Deirdre is going to help us understand what is the force majeure clause, right? What is required to invoke the clause as a result of COVID-19? What are some of the effects of invoking the clause? And potentially some alternate routes that you can use to end a contractual obligation if it doesn't, force majeure does not apply. So Deirdre Huestis is an associate, as I mentioned, at Borden Ladner Gervais. And she practices corporate and commercial law with a focus on mergers and acquisitions, public-private partnerships, and forestry law. Her experience includes acting for companies in reorganizations, dissolutions, international continuations, acquisitions and dispositions of share and business assets, and project financing. So lots going on for you, Deirdre. So welcome. I'm going to hand it over to you. So you can go ahead, Deirdre, and grab your share screen. I'm just going to unmute you here as well. Oh.
There
we go.
Good, okay.
Perfect.
Thank you, Carolee, for that very nice introduction. Hi, everyone. As Carolee said, my name is Deirdre Huestis, and it's a pleasure to be here today speaking to you about force majeure clauses. So, Carolee, is my screen, are my slides, I shared it earlier, but I'm not sure if.
No, here we go. You can go ahead now and grab the screen share.
Do that again. There we go.
Perfect.
Working? Perfect. Okay, so as Carolee said, the outbreak of COVID-19 has caused unprecedented economic concern as it continues to disrupt markets and supply chains around the world. In these times, businesses are increasingly at risk of being unable to perform their contractual obligations. This global pandemic has and will continue to bring many assertions of force majeure in response to quarantines, business closures, and travel restrictions. Today, I'm going to speak to you about force majeure clauses, their application in COVID-19, and when they can be used to release parties from their contractual obligations. So right off the bat, I'd just like to make quite clear that there is no boilerplate instance of invoking a force majeure clause. Every case is different, and whether a force majeure clause can be invoked is very contract and fact dependent. So I'm just going to begin with a bit of background on what force majeure clause even is and where it comes from. Force majeure directly translates from French to mean a superior force and refers to the occurrence of a specific event which is outside the reasonable control of a party and which prevents that party from performing its obligations under contract. In some civil law jurisdictions, force majeure exists as a broad and general principle. However, it is not a general concept of the common law. So because freedom to contract is a cornerstone of contract law, parties can agree that the principle of force majeure will apply to their agreement, and at the drafting stage, they may choose to include a force majeure clause in their contract that stipulates the circumstances in which any or all obligations are suspended or terminated. So in BC, in order for parties to claim relief under the principle of force majeure, they are reliant on the inclusion of a force majeure clause in their contract. The principle will not apply to contracts that do not expressly include a force majeure clause. While force majeure clauses may vary, the Supreme Court of Canada, or the SCC for short, has described their common purpose as operating to discharge a contracting party when a supervening, sometimes supernatural event beyond the control of either party makes performance impossible. The common thread being something unexpected, something beyond reasonable human foresight and skill. While the SCC did come up with this standard in the Atlantic Stock Paper case, it's very important to keep in mind that the SCC was dealing with a specific set of facts and that each case will be different. That decision was made decades ago and with a specific set of facts, and so depending on the wording used in the force majeure provision at question and the commercial intent of the parties at the time of entering into the contract, the standard will still be high, but it may not require the obligations to be impossible to perform or necessarily unforeseeable. For example, in the 1996 Alberta Court of Appeal case, Accor Ltd. And Continental Energy Marketing Ltd., the court found that in this case, contractual requirement for a causal tie between event and non-performance evidences the intention of the parties that the relationship between the two must be substantial, not incidental. A supplier need not show that the event made it impossible to carry out the contract, but it must show the event created, in commercial terms, a real and substantial problem, one that makes performance commercially unfeasible. So the standard in this case was commercially infeasible, not impossible. In terms of interpretation, force majeure clauses are to be interpreted using the same principles as any other contractual provision. In the 2004 SCC case of Satva Capital Corp. And Creston Molly Corp., the SCC stated that decision makers must read the contract as a whole, giving the words used their ordinary and grammatical meaning consistent with the surrounding language of the contract and the surrounding circumstances known to the parties at the time the contract was formed. Force majeure clauses that use standard form language and are a part of a standard form contract will likely be interpreted consistently with earlier interpretation unless there is a good reason to depart from the previous interpretation. So for example, if you are a party to a standard form supply contract, the force majeure provision of your contract will be interpreted the same way as previous interpretations of the force majeure clause in other contracts part of that standard form. So parties enter a contract. Their contract includes a force majeure clause, and something happens to affect their performance, such as COVID-19. Parties can then do a two-step assessment to determine if they can invoke the force majeure clause in their contract. Before I go into that two-step assessment, I just want to pause here and see if there were any questions at this point.
I'm not seeing anything in the chat here yet, Deirdre.
Okay.
So just a reminder to everyone as we go through to pop those into the chat, and we can quickly scan those as we're going through. And yeah, the next time you take a little break, I'll do a quick scan and see if we've got anything come in.
Perfect. We'll just keep moving along then.
Great.
So the first step of this two-step assessment is to assess whether the affecting performance is captured by a triggering event listed in the force majeure clause. So if the event affecting your performance is captured. Force majeure clauses typically include both a list of specified triggering events and a catch-all phrase designed to cover events not specifically listed in the clause. Some examples of common triggering events specifically listed in force majeure clauses include acts of God, which has been interpreted to mean events that could not be foreseen or guarded against, non-natural disasters, such as fires, explosions, and power failures, actions of military or civil authorities, wars, revolutions, and terrorism, changes in laws, regulations, orders, and embargoes, organized labor activities such as strikes, and epidemics and quarantines. Parties to a contract generally negotiate the triggering events to be specifically listed in their force majeure clauses to account for unusual risks as opposed to normal business risks based on their business needs. I'd also like to highlight that from a drafting perspective, the draftsman of the contract should not include items in the definition of force majeure that are accounted for elsewhere in the contract. This is particularly relevant for the example of changes in laws, regulations, orders, and embargoes, because sometimes we see in contracts that that's already been accounted for in a different provision. So contracts should not have overlapping remedies for the same event. COVID-19 related disruptions will likely fall within the scope of a force majeure clause if the clause defines force majeure to include public health emergency, communicable disease outbreak, pandemics or epidemics, quarantines, or government regulation or administrative action. Triggering events can also be catch-all clauses, and so if COVID-19 is not captured specifically or by an analogous term, it may nevertheless be covered by more open-ended language in the contract. For example, in the event that provincial borders shut as a result of the crisis, that event may be captured by a trigger event such as government or administrative action that prevents or hinders performance. Some contracts may include even broader catch-all language for triggering events, such as events beyond the reasonable control of the parties. These broad catch-all phrases would also likely capture the COVID-19 outbreak. However, the language in a force majeure clause should be interpreted narrowly based on the presumption that the parties aren't looking to release each other from their respective obligations unless expressly provided for in the agreement. So having your disruptive event fit squarely into the list of triggering events of a force majeure clause will not on its own provide parties with the freedom to be excused from their contractual performance. This is only the first part of the equation. The party invoking force majeure must also establish that the event sufficiently impacted its ability to perform, so much so that the purpose of the contract is seriously affected at this time. In assessing how COVID-19 may be affecting a party's ability to perform, Canadian courts have traditionally maintained a high standard, a high threshold, and have taken the approach that force majeure clause is only to be invoked if it is essentially impossible for the invoking party to carry out their contractual obligations. So this is where parties seeking to invoke COVID-19 as a force majeure trigger event would have to assess whether the virus is actually making it either impossible or commercially unreasonable, or whatever the threshold is of their force majeure clause for them to fulfill their obligations pursuant to the contract, or if it's more so just become inconvenient or financially burdensome to do so. So far, we've seen COVID-19's impact manifest itself in various forms. The virus may directly affect people's health and prevent them from performing contractual obligations, or it may indirectly affect people's freedom of movement as a result of quarantines. Courts have been reluctant to find the threshold for impact has been met where the interference is financial. In the 2011 BCSC case, Domtar Inc. and Univar Canada Ltd., Univar had a contractual obligation to supply Domtar with caustic soda at a price maximum set by the contract. After the contract was entered into, the global price of caustic soda increased significantly, and in response, Univar sought to increase its prices under the agreement by relying on the force majeure clause. The definition of force majeure that Univar was relying on was any contingency beyond the reasonable control of Univar or Domtar, for example, war or hostilities, acts of God, accidents, fires, explosions, public protests, breakage of equipment, governmental action, or legislation or labor duties, which include Domtar Univar's production, supply, transportation, or consumption practice. The court found that none of the examples listed were tied to economic or market conditions. This provision dealt with the issue of supply, not the cost of supply. The court continued to state that the force majeure would only apply where an event beyond Univar's control affected its ability to supply the product at all or at the quantities set out in the contract. While it may be that the rising prices were beyond Univar's control, this did not affect Univar's ability to supply the contract. The court found that a force majeure clause is not to be resorted to where such an event causes a contract to become dramatically more expensive or makes the performance of that party's obligations commercially impractical unless the parties to the contract have expressly agreed to such a term. So this idea of the force majeure clause not applying to if a contract becomes financially burdensome to fulfill is interesting, and I think it'll be really relevant during this climate. Because much of the impact of COVID-19 breakout is economic in nature, relating to a disruption of consumer and supplier activities, it'll be more difficult for a party to invoke it as a force majeure if the impact claimed by such party involves an inconvenience one would encounter in day-to-day business, as a higher operating or financing cost, or temporary decreases in revenue or cash flow. Unless there are specific references to economic downturn or market conditions in the force majeure clause, it will be difficult for parties to rely on as a result of financial loss due to COVID-19. Again, though, this is all very fact dependent, so it will, if the situation that you can invoke your force majeure clause or not will depend on what's in your actual contract and what that provision actually says. And so to recap, in order for a party to successfully rely on a force majeure clause, the relying party will need to show that their contract's force majeure definition contemplates COVID-19 as a triggering event in some way. 2, that the trigger event was unforeseeable, but again, that will depend if your provision includes that the event has to be unforeseeable. And 3, that the effects of the event make it impossible to fulfill their contractual obligations.
So Deirdre, I just want to pause for a second. One of the comments we have, if there's some other examples, potentially on a smaller scale, like thinking of a small business, how would this impact a small business? An example I can think of, a friend of mine I was just talking to has concerning supply chain issues right now, because a lot of producers have gone to producing PPE and not their standard products, so such as bottling, right, for a small scale food processor. If they can't they have the ingredients, but they can't package and sell anything, but they have a contractual obligation to a third party that's going to resell their product. Is that something that this would apply to? Like if you literally can't create your product anymore because of those issues? And then how do you know what triggering events should be in a contract that you have? So kind of a two-part question.
Well, when you're at the drafting stage of your contract and deciding what to put in your contract, that's up for the parties to kind of decide what triggering events they want to include. And you know, like as I said before, the freedom to contract is a cornerstone of the common law, and so the parties can kind of make this provision as loose or as tight as they wish. Like they can. It comes down to like how easily do you want the other party you're contracting with to be able to break the contract?
Right.
So like how broad do you want to make this provision? Typically you think parties don't want the other party to break the contract. They want this contract to work. And so that's why we're kind of, I guess, a bit hesitant in terms of like loosely interpreting this provision.
Right.
But it really comes down to what's in there, and whether you want, do you want the events to be strictly unforeseeable events, or do you want it to account for economic downturn, or do you want to account for things that we could actually be thinking about? And so you do see a whole range, and that's why every case really is different, and it really depends what your provision says. But I would think if what you're saying, the example you gave of, the producer unable to actually supply or to bottle the product, and like they're physically not able to do that at this time, I would think that would kind of fall within the range, if supply was one of the causation events of the force majeure clause. Like, if it said, if you can't, something that hinders performance, if you can't perform, I would think that would be something that would cause a trigger event to be invoked. Because that's versus, just, is it more expensive for you to bottle the product? Can you still do it? Like, but how? And then we get into this whole argument of, what's commercially reasonable. If it's too expensive, if it's like, if it's unreasonable, for you to still be bottling this product at this time, maybe we just look at delaying the supply. And it's again reasonable to do so. And it looks like one of my slides might have, here, I think they got a bit out of order, but so were there any questions? Sorry, Kirli, other questions at this time?
Let's take a look. So we do have a question about what if there isn't a force majeure clause in the contract? Like, what if it isn't one of the pieces? Will we get into that?
We'll get into that.
Okay, perfect.
Alternate routes you can take. This is just one way to kind of see if you can modify, one way to kind of see if you can modify your contract, but there are other things to look at if you don't have this provision, other doctrines out there as well.
Okay.
And so sorry, continue.
There was just another question about what about the circumstances for nonprofits who depend on fundraising for operating, so the actual impact is not yet felt, but can be anticipated. So they're saying, oh, we're not going to have the money, so potentially don't have the staff to fulfill the contract that we have, so they can see that coming. So they're potentially, and you can chime in just to hear if you want to add that, but maybe they're trying to be proactive, saying, hey, if things don't change, we're not going to be able to fulfill this contract. And that would be one of, again, going back to the triggering event, I believe, right?
I think that's, that will depend on what's laid out in their contract and if that's a circumstance that's been accounted for, if that's been included as a triggering event in the force majeure provision. Okay. I think that'd be one of those kind of fact-dependent scenarios. Okay.
And I know in our pre-session we spoke about this a little bit, but they've elaborated and said the example would be we need to get out of our building lease. Right. So if that fundraising has dried up, they do not have the capacity to pay that lease. Right.
And so is what you're saying that they can't be in their place of operation anymore?
Yeah, would force majeure apply to say, because of the pandemic, our fundraising, our source of funds has dried up, basically, so we cannot fulfill the obligations of this lease. So there's different fulfillment contracts, which we're kind of speaking about here, but then, is this also applicable in a lease contract? I've never,
I don't do very much real estate. I'm not a real estate lawyer, so I've only seen force majeure contracts kind of in the commercial context and commercial contracts. But
we'll park that for right now and continue through today. So maybe that's something that we can look into and provide in a follow-up email, just some content on that. So we'll make a note of that.
For sure.
Perfect.
That sounds good.
So I think that's all for the questions now. If you want to continue through with this example in the slides, and then we'll do another quick pause as well. And again, thank you everybody for putting them into the chat, because we'll just keep scrolling that and address them as we go through. So back to you, Deirdre. Thank you.
Sure. So, I've included here something of a standard force majeure clause. So you can kind of see if you recognize this in your own contract, something of this similar language. And so as you can see, the definition of force majeure includes the triggering events. The force majeure shall include conditions beyond the control of the parties, including an act of God, acts of terrorism, voluntary and involuntary compliance with any regulation, law or order of any government, war, acts of war, kind of things that we were talking about. And the steps required to be taken if invoking such a clause. So in regards to giving the other party notice, if this event is preventing you from fulfilling your obligations, invoice payments, and duties to mitigate. So if well drafted, the force majeure clause should specify effects on the parties' contractual obligations. Although parties are free to negotiate terms, typically the relying party will be required to provide written notice following the occurrence of the trigger event to the other party. The causation requirement will vary from contract to contract, depending on what the intent of the parties was. Did the parties intend for force majeure to only be invoked if the trigger event is a sole and direct event leading to the inability to perform the contract? Is indirect effect sufficient? Does the event causing the event that you're claiming as a force majeure event, does it have to be the predominant cause, and so on? And so your provision will kind of set out what the causation requirement actually is. In addition to providing notice, the invoking party also has a duty to mitigate against the effects of the force majeure event. Back to the Atcourt Ltd and Continental Energy Marketing Ltd case, the Alberta Court of Appeal established that the standard of mitigation is to do what is commercially reasonable and feasible to help limit the losses suffered by the other party to the contract. Because this standard is a bit vague and very fact-dependent, a well-drafted force majeure clause will include certain steps to be taken in order to mitigate upon the occurrence of a triggering event. Often the clause will provide remedies that become available to the other party, such as the right to terminate the contract if the event continues for more than a few days. So parties who invoke the force majeure clause as a result of COVID-19 have a duty to mitigate the corresponding loss and may find workable solutions, perhaps through temporary suspension or partial performance, or by taking advantage of available technologies or resources. So now we're going to get into if you don't have a force majeure clause in your contract. So in the event a contract does not include a force majeure clause, parties seeking to end their obligations as a result of COVID-19 may turn to the common law remedy of frustration. Frustration allows parties to terminate a contract when an event occurs which renders performance of a contractual obligation incapable of being performed, as its performance would render it a thing radically different from what was anticipated under the contract. So the way I kind of think of frustration is if you're contracting with a farmer to buy a cow and he kills the cow for meat, but then says, oh, I can give you a pig. So fulfilling the contract, it's different. Like, you know, getting the pig, it's not what you contracted for. You contracted for a cow. So that's kind of how I think it is. Something's changed that's altered your transaction to make it something radically different than it was before. So unlike force majeure, because frustration is a common law remedy, it is available even where it is not expressly referred to in a contract. The Ontario Supreme Court found in Dillon and PM Systems Management that the doctrine of frustration is not restrictive to any formula and can be applied to all types of contracts. When seeking this remedy, the onus is on the relying party to establish the elements of frustration. So unlike force majeure, you don't need a specific provision in your contract to invoke this doctrine. It's available to you whenever because it is a doctrine of the common law. However, as we will see, it has some pretty stringent requirements. So while the doctrine of frustration is always available, it's unfortunately unlikely to apply in most cases arising during the COVID-19 pandemic. In the 2017 case of Wilkie and Jong, the BC Supreme Court set out the requirements for invoking the doctrine of frustration. So first up, the event must totally change the contract from what the parties had intended. The change must go beyond mere inconvenience. So this goes back to that idea of economic hardship not being enough to invoke force majeure. The same applies here. Something must happen to fundamentally alter the nature of the contract. Making it more difficult or inconvenient to perform will not be enough. Second, the disruption must be permanent, not temporary or transient. So this is a big one for COVID-19 because from what we understand, the current state of affairs putting pressure on businesses and individuals is temporary, and things will go back to normal once we achieve a vaccine or herd immunity. Third, the change must totally affect the nature, meaning, purpose, effect, and consequence of the contract as far as concerns either or both parties. Again, the majority of strain put on contractual obligations as a result of COVID will likely not go to this extent. And fourth, the event must not have been foreseeable. COVID-19 will likely satisfy this requirement as long as the contract was entered into before the pandemic hit. So frustration it's always available, but it would be pretty tough to invoke. It's a bit of a higher like it's even higher, I would say, than false majeure, because false majeure, you depend on what's in your contract. And it might be a little bit less stringent, as we kind of discussed before, but frustration does have that kind of, the nature of your transaction has to be completely changed in order to invoke it. So other contractual provisions to consider if you don't have a false majeure clause, in the alternative of either the false majeure clause or the doctrine of frustration, you can also look to other provisions in your contract that may provide relief. Timing of performance and consequences of delay. So if the party you've contracted with is delaying their performance, perhaps your contract includes something dealing with the consequences of such action. Usually your contract will have a timing provision in there and it will kind of specify if you don't comply with this, it might lead to termination or something of the sort. Termination, if you take another look at what trigger events you've included that will lead to the termination of your contract, and dispute resolution procedures. If you and your party are having issues, you can take a look at the dispute resolution procedures set out in your contract that can assist you in how to proceed with the issues you're having. In deciding whether to invoke their false majeure clause in light of COVID-19, parties should keep in mind their overriding duty to perform their contracts in good faith, as this is likely the lens through which courts will consider a dispute over any of these contractual implications. And it should be, I'd also like to caution that invoking the false majeure clause, it can be a big deal because you are essentially telling the other party that you can't comply with your contract anymore. And so in doing so, I just caution that parties should keep in mind a few practical considerations in deciding whether they really want to do this, including the preservation of commercial relationships. There's likely a better solution than litigation, and it's important to remember that this pandemic will be over eventually. And so if you can kind of figure out a way to make your contract work until then, it could be better to do so than to go to litigation. But again, that will depend on your facts and your situation. Second, the preservation of otherwise lucrative business arrangements. Again, parties should ask themselves whether they're willing to risk damaging this by invoking the false majeure clause. Third, availability of government and financial support. The federal government has been implementing a number of financial programs to help mitigate the effects of COVID-19, and parties should examine whether the programs in place would help alleviate the effects of the triggering event or enhance the ability to mitigate the triggering event. And finally, the preservation of evidence. In the event a party decides to go ahead and invoke the false majeure clause, they should collect evidence to demonstrate that performing the contract from their end was whatever the standard set out in your false majeure clause stipulates, whether that's impossible, hindered their performance, what have you, whatever set out in your actual provision. And that's everything. So I welcome more comments or questions at this time, if anyone has any.
That's great. So lots in there to consider. I like at the end that, like, how can we potentially make this work, right? Before invoking the clause, have you kind of exhausted all means to try and find solutions? So I think that's key, because as you said, this hopefully will end, there will be vaccine, we will change the way that we're doing business, but hopefully, we want to do our best to try and stay in business and maintain those relationships. So that's good. And just going back to the, also looking at what are those government supports as well. So I'll go back to our COVID-19 page, and that has that summary of where you can go to find out a lot of that information as well. So I'm just going to pop into the chat here and see what we have. So again, we're getting a few questions about the commercial lease side of it. So we'll try and gather some information for that follow-up email for you. Another question that's coming in, and this is a two-part, should every contract have a force majeure clause in the terms and conditions? And then what is the difference if there is a liability clause? So I don't know if you need more specifics to answer that, Deirdre, but if you can, you know, take a look as people are looking at potentially entering into new contracts, what should they look for in that clause? And then the difference of a liability clause.
Right. It's up to you. I guess the short answer is for whether you want to include a force majeure clause or not. It kind of gives you that extra layer of security. But the thing is, and that's what we tell our clients, you know, it's depending on how big you want your contract, how much detail you want in there. Like you can spend the time to make a really ironclad contract with it, you know, kind of accounts for absolutely everything, but that just costs, you know, it takes more time, costs more money, depends on your circumstances. If you think there are risks involved, you know, so like always more is better, but it's kind of an economic question as well. Like, do you want to spend time creating like a big contract? And you might, depending on what your circumstances are, and what your business is. But yeah, it's always a good thing to have in there. But you may find that if you like a contract for something that doesn't seem overly complicated, or you know, there's not too many risks involved. Like, you know, I'm thinking like a service contract for kind of a quick service.
Yep.
You may not put that in there because the substance of the contract is going to be over in a short period of time. We don't need to account for, you know, potential acts of God or potential unforeseeable events. So I think it'll depend on your circumstances, but it never hurts. And the difference between a liability clause is what I would think is the force majeure is really about kind of like a catch-all of accounting for things that you haven't really considered and things that could happen, you know, like these acts of God or like acts of terrorism, like things that happen in the world that are out of the control of either party. Whereas the liability clause, I think it's something you negotiate with the other side, saying, you know, we're taking liability for this, or we're maxing our liability amount that you can claim against us to this amount, for things that are a bit more foreseeable, that are more common, you know, like maybe third party liability or something like that. So I think that would be probably the main difference that I think of.
Okay, and then I'm just looking through, and then, okay, just was, sorry, just one of the participants was asking about wording for a clause that they want to put in. So I'm going to read this off, and you can, she's asking if this is reasonable. It says, we reserve the right to cancel any trip for force majeure or any other circumstances beyond our control. So looking at, and this, I'm going to read into this a little bit, but just right now with the state of travel, right? If that was part of what was in the contract, and there's still some hesitation, right, or concerns by the party because of the pandemic, is that something that they could invoke? Like, is that a reasonable clause?
Can you repeat the clause?
She says there's more coming. I in my head I can hear her typing frantically to get this out. It says, we reserve the right to cancel any trip for force majeure or any other circumstance beyond our control.
My instinct is to think, because we know that COVID-19 now, again, it'll depend on your contract and your circumstances, but my instinct is to think that because we know COVID-19 is a thing now, and it depends when this contract was entered into, like if we're talking like drafting a contract for right now, my instinct would be to account for COVID-19 in the contract. I think a court might see this as, okay, well, you knew this pandemic was happening and you haven't really acknowledged it in your contract. And so it depends on whether the provision would say, you know, that the event has to be unforeseeable or not. But if I were drafting this contract now, I would raise COVID-19 as, you know, if something happens, given the climate that we're in, that's further preventing travel and we can't make this happen, we reserve the right to prevent travel from happening. And if the other party is okay with that and that makes it stuff in your contract, then that's fine. But that's just like my instinct, just because we are in it right now and we've known that travel has been an issue for quite a while. My instinct would be to include that. But at the same time, if both parties are okay with it, that's fine too. But I think I could see the other party not being okay with that, considering there's a huge chance that could happen.
Yeah. Okay.
That travel could be prevented.
Yeah. Okay. And great. Trish, maybe she's got quite an extensive question. If you wanted to submit that question to Danielle, Trish, in an email, then we could forward that on to Deirdre, maybe for just a quick follow-up, or a resource that we could share on that point as well. And again, yeah, the questions seem to be on that commercial leasing. I think that's impacting a lot of people right now. So we'll try and share some resources on that as well in the follow-up email. And thank you, Danielle. She's put in the email for you there, Trish, as well. So good. Anything else? Let me see. We answered that question. Is there anything else that anybody wants to ask while we have Deirdre here and available about that force majeure? I'm just going to ask Deirdre, if thinking of a quick contract, I'm a provider of a professional service, an accountant or, some type of service. If you're taking on a major contract with somebody, that's a substantial part of your income. So let's say you're a leadership coach or something, and you have a major contract. I live in British Columbia, the contract's in Ontario, kind of that same thing. Where a lot of those might have a more simple agreement. Is force majeure something that typically in something like maybe a free template that you're going to find online or things like that? Or is it sometimes that extra layer, that extra piece that you want to consider putting in there yourself? Is it something that people should be considering in any type of contract that they're engaging in for providing their service or product?
I think it's always something that should definitely be considered. But then it's also, you can always account for, you can account for remedies in different areas of your contract. Like, how I was speaking before, like if there's something you're specifically worried about, like a change in law or something like that, you can make a provision to deal with that. It sets out specifically what's going to happen. Because the force majeure is kind of like I said, it's kind of like an ambiguous catch-all where we list a few events and then we have, or anything else beyond our control. But if there's something you specifically have in mind, you can make a provision for that, or you can just kind of make your termination clause a little bit more detailed and set out the specific instances as to what will cause you to terminate the contract.
Okay.
But yeah, it's always something to consider if you want to take that kind of extra precaution of accounting for risk. And, during this time too, of COVID-19, it's useful to have that in your contract, but we do have to remember that invoking this provision, it's quite a high threshold needs to be met. It's not automatically as we said, if something happened and it's in there, I don't have to do what I said I would do in my contract. It's quite high. It has to show that your actions were either, really severely hindered or made impossible or whatever however tight your provision has been drafted. And so, if it is, like I said, a loose provision, that's fine, but I doubt parties would ever draft such a provision. And so, it depends on your circumstances, but I think it's always something to be considered. I'd always kind of consider, how well do I want to be protected? And, what's the cost benefit of that? Is it going to am I just getting ridiculous here? Making this big contract for something that,
right,
for circumstances that aren't going to happen, and just paying so much money to the lawyers to draft this big contract, or can I get by with, a little bit less? So it's always kind of a balancing question for yourself. Does the economics outweigh the risk?
Yeah. And going to that economics piece, because you said, I believe earlier, just because if your costs go up or things change kind of in the marketplace, is there a way to protect yourself if, as an example, I'm going to go back to the, small scale food processor, if all of a sudden the cost of the packaging and everything doubles, is it possible to have a clause in there that says within a certain threshold, the price will not change, but if there's some severe impacts in the supply chain that those adjustments can be made? Is that something that you've seen in contracts as well?
You can absolutely have a provision dedicated to, you know, economic downturn or market downturn, aside from the force majeure clause. Like, and that's what that Domtar case, you know, the court found that they found that, you know, you don't have anything in here dealing with the economy. Like, your force majeure clause is dealing with, can you actually supply your product, not whether it's made it dramatically more expensive for you. And so in that case, the court found, had you had, you know, a separate provision that dealt with this, then of course you can look to that for your remedy. So yeah, you can write anything up in your contract. And so if you that's a worry for you, you know, the market changing, you can certainly put a different, I would think you could put a different provision kind of dealing with that. And if both parties are okay with it, that's fine.
Yeah. And I think that's the key, right? Is both parties have to agree on what those terms and conditions
like you can
are.
Write whatever like things that are good for you, but you see that other party to say, yeah, or like, we're not okay with that. Like, we don't want to deal with the risk of, you know, the economy. We want to make sure that we're getting our product. And so that's the balancing act.
Okay, good. And then I don't see any other questions coming in. If anybody's got anything they want to jot down, we've got a few more minutes left here. I am going to bring up and just mention, Deirdre, let me see here if I can grab my screen now.
And just, I'd like to just also, you know, really emphasize again that these provisions, the application of these provisions, they're all very fact dependent. Each case will differ. There's no kind of boilerplate application to all of them of like, oh, it needs to be impossible or it needs to be this. Like, as we saw with that other case, the impossibility wasn't the threshold. It was just kind of commercially unreasonable. And so every case kind of will differ. Yeah.
And then jumping off that, just the next in our series with BLG and the Driven by Women program is around small claims. So also some of the things that we're seeing come up now, right? People aren't getting paid for product or services they delivered, pardon me, before COVID-19, et cetera. So what is that process? What are some of the remedies that you can take as well? So we'll get into, you know, small claims and dispute resolution and the options and opportunities that you have there as well. So great. I think we'll wrap it up. Again, just if there's any outstanding questions, put them in the chat and we'll try and answer them in that follow-up email for you. I want to thank especially Deirdre for joining us today and sharing information on force majeure. And thank you for providing the slides. I've made a note that we're going to share those out with everybody as well, so that you can reference that and go through, because I know there's a lot of information to digest today, lots of things to consider when you're looking at those force majeure clauses, and if you don't have one, what are some of your opportunities? So thank you so much, Deirdre. Thank you everybody for joining us. Again, we'll be back here with another in the series on small claims court, and we'll send out a follow-up email. We'd love to get your feedback. We'd love to hear what other topics we can support you with as well. So please do the short survey that we send out to provide that feedback for us. So great, thank you, Deirdre, very much. Thank you, Danielle, in the background for fielding the questions as well. And enjoy your day, everyone. Thanks so much.
Thank you, my pleasure.
Bye, everyone.